magiliw, perlas ng silanganan, alab ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupig, di ka pasisiil. Sa dagat at bundok, sa simoy at sa langit mong bughaw, may dilagang tula at awit sa paglayang minamahal. Ang kislap ng watawat mo'y tagumpay na nagriningning. Ang bituin at araw niya kailan pa may di magdidilim. Lupa ng araw ng walhati pagsinta, buhay ay langit sa piling mo. Aming ligaya na pag may mga api, ang mamatay ng dahil sa'yo.
Thank you very much. Please be seated. To welcome us all to the 7th UP Law Centennial Lecture, I'd like to call on Professor Concepcion L. Hardelesa to give us the welcome remarks on behalf of our Dean, Dean Danilo L. Concepcion.
Good afternoon. Many of you here are aware of this special lecture series, but let me say a few words on what this is all about. To mark the 100 years since the founding of our college, two major programs have been undertaking owing to the support of our generous alumni. One is the textbook writing, where several of our faculty have signed to produce legal readings, case books, and the like. Last June, we launched the first of this textbook, Mestizo by Dean Pacifico Agabin. The second undertaking is the Law Centennial paper. This consists of lectures delivered by statistical scholars among our faculty and alumni. The lecture had been grouped into two types. One falls under the heading of Looking Back at Law's Century, which examines the development of law during the 100 years and its relevance to contemporary reality. So today is all about history, that of our college and that of our country. To speak to us this afternoon is the UP College of Law resident scholar of legal history. Dean Agabin was with us for the launching of his book. Today, or this afternoon, he is back for the Law Centennial lecture on the common law century, the age of capitalism and globalization. I must say we are into a scholarly mood, so ladies and gentlemen, I invite you to enjoy the lecture and participate in the open forum. Have a good day.
Let me just say a few words about our lecture this afternoon. Our speaker for today is a distinguished academic, as we all know. He is a professor and a former dean of the UP College of Law and a successful and prominent law practitioner who has made great contributions in Philippine case law. As many of you are aware, Dean Agabin recently just authored a textbook, Mestizo, the story of the Philippine legal system, which traced the roots to the development of the Philippine legal system from the Spanish period up to the present day. In his book, Dean Agabin also noted the American or common law influences and effects in the Philippine legal system. In his lecture this afternoon, Dean Agabin continues to explore these pieces, influences, and effects by examining the development of the common law system in the United States and how it relates to the capitalist system and economic globalization. As in his book, Dean Agabin would discuss how these developments in the American economy and the legal system have taken root and influenced the Philippine economy and the legal system. In this fast-paced and ever-changing age of multinational corporations, outsourcing and borderless transactions, we are privileged to have a legal scholar to the caliber of Dean Pacifico Agabin to discuss these influences and effects this afternoon. Our lecturer this afternoon on the common law century, the age of capitalism and globalization, Professor Dean, former Dean, Pacifico A. Agabin.
letter from then Dean Barbiglionen inviting me to this lecture. And actually, he gave us two choices for a topic. The first choice was looking back at the lost century, and the second was the role of the UP College of Law in Philippine law and society. Well, I decided that I should choose the more general subject and to be less parochial, because it's more interesting looking back at the lost century in relation to present-day events. So we look back at the lost century, specifically from 1911, when the UP College of Law was founded, up to the present. And we see that the century was really the century of the common law, as distinguished from the civil law system. So why is that? Well, we know very well that law is a reflection of power. And the last century has been dominated by American power, which of course has the common law system. And so under Pax Americana, the common law system was imposed virtually on the other countries which traded with or have been colonized by or are satellites of the United States. And even in the century before, from 1811 to 1911, was Pax Britannica, no? Which also has a common law system. And since these two common law countries dominated the world, it's only logical that they should impose the common law system upon the subject countries. So, as I said, law is a reflection of power. When the Roman Empire was at its height, it also imposed the civil law system upon the satellite countries. And when Islam was the dominant religion, it also imposed Sharia on the Islamic countries and so on. So it's not surprising that the last century was the century of the common law. So what is the ideology of the common law? Well, we have, of course, individualism as the dominant ideology of the common law. By 1911, for instance, the United States had entered into the age of laissez-faire. In jurisprudence, we saw the advent of what the Americans call the Lacknerian era. This is with reference to the case of Lackner versus New York, where the American Supreme Court invalidated the New York statute setting maximum hours for bakers. And that started the Gilded Age of capitalism, which is a term borrowed from the historians of the United States. And at that time, the United States was already in the golden age of capitalism. It had developed what the sociologists call the business civilization, a civilization characterized by sanctity of private property, by liberty of contract, by industrialism, as seen from its many factories, its banks, its laboratories, and so on. Its profit motive that goes with a business civilization, and of course the usual business establishments like capital investments, like credit financing, and so on. And the Philippines then, of course, was a colony of the United States. An American writer says that the overriding policy of the United States with respect to the Philippines was to create the Philippines in its own image, which I think partly succeeded, although it was not completely successful. And anyway, with respect to the common law, there is an elective affinity between the common law system and capitalism, because as it developed in the United States, the common law rested on two basic pillars, which are also basic economic principles. The first is the right to property, and the second is, of course, liberty of contract. So these two principles are also the hallmarks of American constitutionalism. That's why the term constitutionalism has a different connotation from constitutionalism as we know it here. Because American constitutionalism is basically economic in nature. And it is acknowledged by American historians that the courts of the United States had intently and purposely geared American case law towards the two basic pillars of capitalism, the protection of property rights and enforcement of contracts. So in the United States at the time, and also of course at that time we were already a colony of America, a legal culture developed which centered around sanctity of private property and freedom to contract. The economic philosophy in the United States at that time was free enterprise on free markets. And so this economic philosophy was also carried over to the Philippines. starting with William Howard Taft, who was bent on inviting American direct investments into the Philippines to develop it. And so the Taft policy also with respect to the judiciary at the time was to appoint Americans as judges. In a private letter to a friend, for instance, Taft had confided to a friend that he did not trust the Filipinos at all as judges. He said, the number of honest judges in the Philippines can be counted with the fingers of one hand. And these were probably the Filipino justices in the Supreme Court. He reversed the ratio of set by General Arthur MacArthur, because when Arthur MacArthur was military governor of the Philippines, he made it a point to appoint a majority of Filipinos in the Supreme Court with 4 Filipinos and 3 Americans. But when Taft took over, he reversed the ratio. He made it a point to appoint 4 Americans to the Supreme Court and 3 Filipinos. Well, anyway, the point is that almost all of the trial judges all over the country were from the United States, and these trial judges were educated and trained under the common law system. So if you appoint judges to interpret the law, to resolve disputes, whether the legal system be the civilian system or the common law system, consciously or unconsciously, they would infuse common law principles into the jurisprudence of the country. Not only that, the case method of the common law, which was also the method adopted here in the UP College of Law when Malcolm first started it. The case method which is peculiar to the common law system, has a distinct advantage over the civil law system. Why is this? Well, because the case method is based on empirical evidence. It utilizes inductive rather than deductive logic. Unlike the civil law system, which uses deductive logic, using very abstract principles drawn from what are considered fundamental and universal principles written in words of fire in the hearts of men, if we are to quote Jorge Bucobo. And of course, between abstract principles and concrete rulings of the Supreme Court in decided cases, it's the concrete rulings which prevail, because the principles under the civilian system may be too abstract as applied to a given set of facts. So while the Philippine legal system is supposed to be hybrid, a mestizo, gradually, as observed by Justice Malcolm, there developed a Philippine common law system. And eventually, it became more dominant than the civil law system. So then, going back to the United States, we saw therefore the rise of the free enterprise system. And we can see from the constitutional history of the United States that the economic philosophy of free enterprise gave birth to constitutional principles which are calculated to protect business interests. This is, of course, illustrated in the development of the due process clause of our Bill of Rights, which we copied from the United States. No? Originally, the due process clause, which the United States in turn borrowed from the Magna Carta of England, it was a guarantee of procedure. Before a man can be deprived of his property, you have to take the following steps: notice, hearing, trial, argumentation, debate, and then judgment, and so on. This is procedural in character. But in the United States, the due process clause also developed a substantive aspect. It's a mutant, actually, because the substantive aspect of due process tells us that any piece of legislation touching on life, liberty, or property, or any executive act, or any act of an administrative agency should be fair, it should be reasonable, it should not be oppressive, and so on. So, how did this come about? Well, it came about, as I said, starting with the case of Lackner versus New York, and then assisted by leading scholars in the United States, like Thomas Cooley, who wrote a treatise which we are still using as reference today on constitutional limitations. And then there was Christopher Tideman, who also wrote on limitations of police power. And then we had a scholar in the American Supreme Court, Stephen Field, who was the vanguard of the free enterprise philosophy in the United States. And of course, these leading lights were assisted by the cream of the American Bar Association. As you know very well, in any country, the cream of the Bar Association will always be attracted to where the money is. And so the American Bar Association had spearheaded the acceptance and the endorsement of the free enterprise philosophy in American law. So leading cases like Yickwo versus Hopkins and Dartmouth College versus Woodward laid down the philosophy of law that individual liberty should prevail over police power in this protecting property rights and preserving liberty of contract. It was also in these cases that jurisprudence in the United States began to divide between public law and private law, so that private law was suffused with the philosophy of individualism in business. All of these decisions of the American Supreme Court were imported into the Philippines simply because we had American judges here. They were told to apply American precedents, not to mention the fact that the decisions of our Supreme Court had to be appealed or could be appealed on review to the American Supreme Court. So we see how a dominant economic philosophy can influence the course of jurisprudence. And that is what happened in the common law. So with globalization coming back, I say coming back because globalization is really just capitalism on an international scale. We see the dominance of the common law system, not only in the United States and in the United Kingdom, but also in other countries, insofar as the commercial laws, the lex mercatoria, is concerned. However, we all know that capitalism, as it developed in the 18th and 19th centuries, is somewhat different from capitalism as we know it now at the international level. So, in our day and time, what do we see? We have seen the scientific revolution giving birth in turn to the technological revolution. Capitalism is no longer the fair market competition that we saw from the history books during the 19th and early 20th century. Capitalism now, or globalization, is much more high speed, much more expansive, much more imperialistic than capitalism in the early 19th century. We are now part of the global village. We have interdependence among nations instead of independence. We now have very porous national borders, and we see the triumph of the oligarchic sectors in capitalist countries. So what we see now is a concentration of economic power. And that probably explains why constitutions which were promulgated during our day and time are much more lengthy, much more complex than constitutions which were crafted in the 18th and 19th centuries. Because the framers of our Constitution saw the concentration of economic power in the country, and they sought to regulate not only political but also economic power. So now we have a very lengthy 1987 Constitution. I think you students of today should be very thankful that you're not required to memorize the whole Constitution anymore. In our class of 1960, our constitutional law professors required us to memorize the whole Constitution. But that was the 1935 Constitution, which is much shorter than what we have now. But anyway, the point is that there is need to regulate not only political power as a source of abuse, but also economic power, which is a source of abuse at present. So, the ideology of globalization and that of common law are somewhat parallel, because common law as a system is much more accommodating than the civilian system to strong economic pressure. As I said, the common law system is not only a body of substantive law, it's also a mode of reasoning. And as a mode of reasoning using inductive logic, it can change its premises, because its premises are facts, individual facts, from which you draw a generalization. So, the common law system is much more flexible and malleable than the civil law system. And it is based on concrete and actual facts rather than on abstract principles of law. So, at present, what have we got? We now have the lex mercatoria, the common law for the common market. And the common market is not really Europe only. It is the whole world, except for hermit countries like North Korea and Cuba and the countries in Africa, which are ruled by dictators. In other words, the thesis of Henry May, that in progressive societies, the law moves from status to contract, now holds true again. And the source of law, especially commercial law at present, is shifted from political power to economic power. It sees people not as a sovereign whole from which all government authority emanates. It sees people individually, and it sees them as economic units and not as political atoms. And so we can see how the common law can easily accommodate itself to the pressures of the common market. And there is while the principles of 19th century common law, especially constitutional law, have been carried over to our day, namely sanctity of private property and liberty of contract. We have the same principles today, except that the definition of property at present has expanded in much the same way that the definition of contract at present has also expanded. It has taken on a different shade of meaning. In the 19th century, for instance, property was thought to be only involving tangibles. That's why you will see in the categories of property under our civil code, we have only two categories: immovables and movables, probably referring to tangible property. At present, our concept of property is completely different because aside from tangibles, property now includes intangibles. And these intangibles are the very sources of economic power of the globalists. So we see property now as a bundle of rights, not as physical objects. And property, the more important aspects of property in our day and time are the intangibles like intellectual property, franchises, trademarks, patents, goodwill, reputation, and so on. These are all emanating from business interests. Of course, with the advent of the welfare state, there was also a different expansion of property towards the more democratic side. Property under the welfare state included largesse from the government, like unemployment compensation, trading stamps, retirement benefits, calamity funds, and so on. But the trend at present is that the coming of the global state is gradually dismantling the house that was built by the welfare state. So we see how, for instance, the definition also of contract has expanded. Contract used to be the traditional bilateral agreement between two parties or three parties, but now it has a very expanded scope, composed of treaties between nations or business arrangements between multinational and transnational corporations, loan agreements between countries, loan agreements between private financing institutions and local companies. And of course, what comes with these loan agreements, with these trading agreements? It comes with what the World Bank calls conditionalities or conditions imposed upon the borrower. And these conditions are, of course, imposed by the creditor countries or by the creditor financing institutions. And this has blocked the movement towards the welfare state because it is these conditions or it is these conditionalities which dismantle the house built by the welfare state. So, in short, commercial law, the lex mercatoria, is now being shaped to a large extent by the monopolies and the oligopolies at the global stage. The problem with this redefinition of contract is that it tends to bypass our democratic processes. When the Philippines borrows money from the World Bank or even from a private bank like ING or Deutsche Bank and so on, it does not present the terms of the contract for ratification by the people. The loan agreement is merely reported to Congress after the fact. Or if we borrow a big amount from the World Bank, the IMF will impose conditionalities, which are usually terms to achieve privatization, deregulation, liberalization, free enterprise, and at the same time, protection for the dominant economic interests. So, what are the principles which are advocated by the creditor countries and the creditor financial institutions that lend money to the poor countries? Well, we have first, the conditions would insist on free trade across borders. Well, of course, this is now fact. No? At present, it's a reality which we have to face because we chose to become a part of the world trading system, starting with the martial law of President Marcos. Then, so we are part of the integrated trading and financial system of the North countries. Then we guarantee free movement of capital across borders. Then, of course, this movement of capital and so on, even movement of goods is ably aided by the technological revolution which we see in our day and time. And then we have the insistence on privatization. So even in our country, we see privatization being carried out by our government, selling the National Power Corporation, other utilities, and so on. The sad fact is that we even see privatization of governmental functions. For instance, there are more private security guards now than policemen. And even the administration of justice is being partly privatized. How is this done? It's done by referring civil cases initially to private mediators. And that is why Congress had to pass the Alternative Dispute Resolution Act of 2004. Well, anyway, privatization would involve what is now called outsourcing. This dispute between Philippine Airlines and PALEA, the Employees Association, is a good example of outsourcing. And we see the effects of this scheme in terms of efficiency from the viewpoint of Philippine Airlines, although from a national point of view, I don't know if it is efficient for a country to put aside its workers and employees without any function anymore in the name of efficiency and profit making. Anyway, aside from privatization, the creditor nations also insist on liberalization and deregulation. So we have liberalization of tariffs, for instance. We are constantly under pressure to lower our tariffs. Then there is this very strong pressure to do away with the nationalistic provisions of the Constitution. So now you see the Senate and the House agitating for constitutional amendments of the economic provisions of the Constitution to do away with the nationalistic provisions and attract foreign investments. So, for instance, do away with the nationalistic requirements for ownership of land. So I'm sure the Chinese can buy up all of the agricultural lands that we have here and devote it to a jatropha plantation so they can have oil and so on. Then we have liberalization of labor. So the companies are asked to curtail the usual perquisites of labor like the cost of living allowances, maternity leaves, the other perquisites which are given to workers like vacation pay and holiday pay. Then we also have liberalization of financial transactions so that hot money in the form of sovereign funds, corporate hedge funds, virtual money can move easily across borders. And then we also see self-regulation being adopted by our government agencies to allow private entities to regulate themselves, private businesses. Would you believe that a big ticket like the government securities is not being regulated directly by the central bank or by the SEC anymore, no? It is the SEC has designated a cartel, the Bankers Association of the Philippines, to self-regulate the government securities market. And government securities is a ₱1 trillion market every year because the government borrows and borrows money from investors. It is bigger than the stock market. And yet, the central bank and the SEC have delegated this function to a private entity formed by the banking cartel. Anyway, what comes out is instead of the rule of law, we see the rule of the mighty. It is social Darwinism in its barest form. This survival of the fittest. And the fittest happens to be the big companies with the bulk of corporate funds at their control, or the companies with advanced technology, or those with the big banks who are holding sovereign funds, for instance, or pension funds. And then, so all of these are forms of control exerted by the big capitalist countries upon the debtor countries. And the debtor countries are forced to pass laws and regulations because these are conditions of the loan agreements. And since we have no choice but to borrow, we have to abide by these conditions. So even the independence of the central bank has been eroded because of these conditionalities imposed upon us by the World Bank. So, atop the central bank building in Malate sits the office of the IMF, for instance. And literally and figuratively, they are atop our central bank. So, survival of the fittest in the commercial international arena is survival of the biggest, the strongest, the richest, and of course, the entities with the most advanced technology. So as they say, globalization is a game of winners and losers. There are winners and there are losers, and the winners take all. It's a winner-take-all game. And that explains how the welfare state can be dismantled easily by globalization. Who enforces all of these laws and regulations tending towards liberalization, deregulation, privatization, and free enterprise? Well, of course, we have our judiciary, which has no choice but to enforce the laws passed by Congress, but these are being monitored by international policemen like the World Trade Organization, the IMF, the World Bank, and private entities like the International Chamber of Commerce or the International Council for the Settlement of Investment Disputes. In fact, the companies engaged in joint venture with Philippine local companies can easily escape the sovereign power of the state. How do they do this? Well, it's easy for them because every agreement, every joint venture agreement, every loan agreement contains an arbitration clause. And this arbitration clause provides that in case of any dispute involving the terms and conditions of this agreement, it will be initially and finally referred to arbitration. And of course, arbitration is conducted under the auspices of the ICC, or disputes on investment agreements is arbitrated by the ICSID, or the International Center for Settlement of Investment Disputes. This is what happened to the NAIA Terminal 3. You know that the contracts involving NAIA Terminal 3 had already been passed upon by the Supreme Court as null and void. And of course, we know that contracts which are null and void can no longer be the source of rights and obligations. What happened here? The contractor, Piatco, brought the Philippine government to arbitration in Singapore, which is under the ICC. On the other hand, the financier of the project, the Frankfurt Port Authority in Germany, brought the Republic to arbitration in Washington, D.C., and that is where they are now. No? The sad part is that when the Republic was dragged into arbitration at the ICC and at the ICSID, the Republic had pleaded lack of jurisdiction on the part of the arbitral tribunal because the Philippine Supreme Court had already adjudged the contracts as invalid. And of course, the arbitral tribunals did not sustain the Philippine government on the principle of competence, namely the principle that an arbitration clause should be separately adjudged from the main contract. The arbitral tribunals upheld their jurisdiction over the Philippine government. And in fact, they proceeded to determine whether the decision of the Supreme Court in the Agabin case is valid or not. Imagine a private entity like the ICC trying to determine whether a decision of our Supreme Court is valid or not. Or the International Center for Settlement of Investment Disputes determining whether a decision of the Philippine Supreme Court is valid or not. So you can see how political power has been emasculated by economic power. So, insofar as disputes involving commercial laws are concerned, therefore, we see how the big economic giants can easily escape the sovereignty of the state and invoke the common code of conduct which are acceptable to them. And insofar as disputes are concerned, we now have in business circles involving joint ventures, loan agreements, project financing, and so on. The disputes are under what they call now an arbitration culture. So, last week, we read that the 6th or 7th richest man in the world, say George Soros, has, well, he landed number 6 or number 7. He was the one himself who outlined the problems of globalization for third world countries. First, according to Soros, there is uneven distribution of wealth. Well, this is now a fact because under globalization, we now see how the winners have concentrated resources of the world among themselves and how the losers have lost. For instance, according to a United Nations Development report, it is said that the wealth of the 3 richest individuals in the world is more than the gross domestic product of the poorest 48 countries, while the 32 richest people in the world have more than the gross domestic product of sub-Sahara Africa. And the 32 richest people in the world have more than the gross domestic product of the countries in South Asia. Then the richest 1/5 of the world's population consumes 86% of its output, and the remaining 14% of the world's population consumes the rest. While the richest 1/5 consumes 58% of the world's energy output, the poorest 1/5 consumes only 4%, and the top 1/5 consumes 58%. So, on food, the top 1/5% of the richest consume 45% of meat and fish, and the bottom 1/5 consume only 5% of meat and fish. With respect to motor vehicles, we have 87% of all the motor vehicles in the world are owned by the richest 1/5. But the bottom rank own only 1%. Again, the top 1/5% use 74% of the world's telephones, but the lowest one-fifth use only 15%. So the irony here is that while the richest countries consume the world's goods and services, it is the people in the poorest countries who pay a proportionately higher prices for the resulting pollution and degradation of the environment. And with respect to the consumption of goods, for instance, we have here the report as of this year, 2011, where the richest 1% of adults in the world control 43% of the world's assets, and the wealthiest 10% have 83%. The bottom 50% of the world's adults have only 2% of the wealth of the world. In terms of capital, the wealthiest 10% control the vast bulk of capital, while 50% have none. There are about 1,000 individuals who are billionaires in terms of dollars, with 1,000 of them who are billionaires, 2,800 who control more than 500 million each, 30,000 control more than $100 million each, and 27,200 control 50 million in assets. Now, of course, in the Philippines, the lopsidedness of wealth distribution is even more accentuated. According to the IMF, the Philippines is one country where we have the most unequal distribution of resources. According to the UNDP report, the richest 10% among us is 24 times richer than the income of the 10% poorest. In food and consumption, the rich consume 10 times the level of the poor, and they spend on clothing 18 times more than the poor, 41 times more in housing, and 11 times more for fuel, light, and water. So, globalization is really a game of winners and losers. Then, the second problem enumerated by George Soros is the instability of financial system. Well, we read this now in the newspapers. No? Greece is reeling from the debt crisis, followed by Portugal and Spain and some other European countries. Peter Drucker attributes this to virtual money, which is actually money that has no existence outside the global economy and its money markets, because it is created primarily by currency trading. So this money is created in economic activities like investment, trade, production, and consumption. Then we have global monopolies and oligopolies, again cited by Mr. Soros, although he himself is controlling one monopoly in investment. And then he cites further the ambiguous role of the state. Well, as I said, the state has become less and less powerful vis-a-vis the economic power of the big transnational companies and, of course, the dominant trading countries. We see how the policies which they enforce have undermined democratic politics, and how they are taking us back to the Gilded Age of capitalism in the United States. So economic power is becoming much more a source of abuse, and the sovereignty of the state has some difficulty curtailing abuse of economic power. So, what are the implications of globalization for the Philippines? Well, since we are a borrower country, we have to pay the costs of being a borrower. What are the costs? We have political costs, no? Like the weakening of the state to override economic abuse, for instance. The erosion of sovereign power is so clear in our day and time. For instance, while the creditor countries feel free to print as much money as they want, we do not have that freedom anymore, because we are prohibited under the conditionalities of the World Bank to print more money, naturally, because they would not want to receive payment in worthless currency. Then, in extreme cases, for instance, we trade sovereignty for a mess of pottage. Look at what Mr. Marcos did in imposing martial law. He wanted the Philippines to join the newly industrializing countries, so he imposed martial law and imposed upon us economic policies calculated towards integration with the international trading market. We shifted from import substitution to exports. And so, notwithstanding martial law, however, and the efforts of Mr. Marcos to create a bagong lipunan, we were not able to join the newly industrializing countries, probably simply because we could not adapt ourselves to a business, to the culture of a business civilization. Then we have also to pay the economic costs of being a borrower. What are the economic costs? Well, we see around us how poverty has increased, notwithstanding the increase in our gross domestic product. For instance, we see a constant rise in our gross domestic product for the last 10 years, which peaked up to 7% in 2007. And yet, during that same period, the incidence of poverty also increased when it should be decreasing. Why? Because our policies make the rich richer and the poor poorer. And this happens because, as I said, the safety nets which come with the welfare state, like food supplies, or free medicine, or subsidized costs of transportation and communication, and so on, are discouraged by the creditor institutions. So at a time when our gross domestic product peaked at 7%, the poverty incidence of the Philippines also increased by 0.9%. So the economic policies which we have, for instance, to make our country competitive, like incentives for foreign investors, tax holidays, multinational headquarters, and even one-stop shops, and so on. All of these are, of course, very good, but sometimes it redirects national priorities from social welfare to economic objectives. And the principal economic objective that we have now is the attraction of foreign investments, to the extent that we have to even amend our constitution just so we can accommodate, or we can attract foreign investors. So we are willing to scrap the nationalist provisions of the Constitution, land ownership, corporate control, and so on, just so we can get foreign investments. And at this point, we hardly have any choice, because we even have to compete with our neighboring Asian countries in attracting foreign investments. So we cannot afford to lag behind our ASEAN neighbors, notwithstanding our membership in a collective regional arrangement. So anyway, we go back to the role of law in a globalized economy. And so as lawyers, and most of us here are lawyers and law students, we again have to redefine the role of law in a globalized economy. We have to redefine the concept of justice, just as we redefined the concept of justice in the 1930s to include social justice. And jurist Ronald Dworkin has defined justice to mean the right outcome of the political system. But of course, determining what is the right outcome is precisely our problem. And we, of course, have economic, social, and cultural rights in our Constitution. We also have economic, social, and cultural rights in the Universal Declaration of Human Rights. And we have the same economic, social, and cultural rights in the International Covenant for Economic, Social, and Cultural Rights. But these are abstract concepts which can easily be eroded by interpretation and construction, either in our judiciary or in the arbitral tribunals. For one thing, the general principles laid down in our Constitution, like the economic principles, fair day's wage for a fair day's work, the right to work, and so on, has been eroded by the principles of deregulation and privatization and liberalization. The basic principles laid down in the Declaration of Human Rights, the right to human dignity, the protection of labor, protection of women and children. These are very abstract concepts which can easily yield to specific rules and regulations enumerated in the 500-page treatise of the World Trade Organization. As you know very well, we have a role in statutory construction. No? The specific provision prevails over the general provisions. In much the same way that abstract principles will have to yield to specific rules and so on. So the law needs to acquire a new perspective in much the same way that the common law of England, for instance, had to devise the concept of equity when the common law became too harsh. And the English concept of equity emphasized more on the procedural writs to temper the harshness of the common law. Writs of equity like certiorari, injunction, prohibition, mandamus, and so on. We have to find new ways to override economic power. Otherwise, the rich will always get richer, and the poor will always get poorer. So we have to redefine justice in the context of a globalized economy. We have to redefine equity, the content of equity in the context of the common law. And so through political power, we have to found a new ideology. A new ideology that emphasizes not only on life, liberty, and property, but also on liberty, equality, and fraternity. Salamat po.
Okay, we will now open the floor for questions that you may have of Dean Agabin. We have a microphone at the center aisle. Please identify yourselves so we will know how to address you. Any questions? Yes, ma'am.
Good afternoon, sir. My name's Samantha Turthus. I'm from Dean Agabin's legal history class. I actually have two questions. The first question is a two-pronged question. Bear with me. My first question is, sir, would you say that that capitalist globalism or capitalist globalization has brought about this concept of universal secular values and paradigms imposed by the world's hegemons through international law and agreements? And if so, Could you expound on that? And the second prong would be, what's the interrelation of that to Philippine domestic law and how it is applied to Filipinos in the grassroots level?
Yes. Well, as we proceeded from from the premise that law is a reflection of power, then it follows that the dominant ideology will dictate what the outcome of the law here would be. In the Philippines, for instance, we hardly had any choice because the law was imposed upon us by our colonial masters. So we had the civilian system imposed upon us by Spain, which is at least founded on political power. Then later on, we had the common law system imposed upon us by the Americans, which of course was also founded on political power. But because of the economic power of the big American corporations at that time, and because the civil governors who presided over the Philippines had wanted to develop the Philippines along the lines of American civilization, then we had to adopt laws which are appropriate to a business civilization like the United States. So as a colony, we had no choice. Then when we were granted independence, actually we were granted only political independence, no? And unfortunately, it came at a time when we were devastated by the Second World War. So we had to depend economically on Mother America. We had to pay the costs, like dependency upon American economic fortunes. We have to yield aspects of Philippine sovereignty. That's why we had to amend the Constitution by passing the parity bill, which enabled American citizens to exploit natural resources of the Philippines. And then later on, we entered into the Laurel-Langley Agreement, which further made the Philippines dependent on the United States. So how about American jurisprudence? Well, as I said, the substantive aspect of due process was also incorporated in Philippine law because we used American precedents in deciding cases simply because most of our laws were copied from the United States. And so, in a sense, Stanley Carnot, in his book, In Our Image, was right in saying that the Americans tried to carve us out into their own image, and in a sense, they were a success, although essentially it was a failure. I think on the commercial side, they were a success because now we are trying to adapt to the practices, the usages, the customs and traditions of a business civilization. That is our concept of being civilized. I recall that when the city of Isabela in the province of Basilan put up or established a branch of McDonald's, the president took it as an index of civilization coming to the province of Basilan. So we really adopted the ethics and the mores of a business civilization.
My second question is, in light of the recent economic meltdown that the U.S. and all these countries all over the Eurozone are experiencing, or the quote-unquote failure of capitalism, do you see a impending change in the dominant worldview as, capitalist tenets as gospel truth, and the blind belief in the invisible hand, and all these other universally accepted capitalist tenets, now that the recent economic meltdown seems to indicate a failure in the model of capitalism? Do you see any impending change in the worldview then?
I don't think so, because even if countries of Western Europe may suffer from a financial meltdown, and even if the United States is having a problem with its credit ratings downgraded by Standard and Poor's, the United States has the military muscle to remain as the dominant world power, at least during your lifetime. The missile diplomacy of the United States is sufficient to support its economic power. So do not dissociate economic power from military power, because forms of power are agglutinative. By agglutinative, I mean forms of power attract each other. So political power attracts economic power attracts military power, and so on, so that it concentrates power at the center. And that is what is happening at the international arena.
Thank you, sir.
Okay, next question is, please.
I'm Gino Pai, also from 1E. Sir, you have masterfully showed us how globalization has, in a way, compromised and jeopardized welfare states in domestic settings, in our own. But we see from an international perspective a trend of countercultures coming from the green roots, coming from the grassroots. Coming from the grassroots, from the masses themselves, a counterculture against welfare states. We see in America the Tea Party. We see in Russia the rise of the ultranationalist youth, almost reminiscent of the Brown Party of Hitler. We see in Britain the impoverished urban youth not having any skills because of too much welfare dole-outs, etc. They don't go to school anymore, and they just go to riot. They go to the streets. In Tel Aviv, for the first time, we see people in the streets. Of course, there's a sense of xenophobia, a sense of them not. It's beside the point, but the immigrants they don't want welfare for the immigrants. But even among themselves, these people seem to react to the idea of not wanting the state to give dole-outs to people who are in situations that are dire. Do you see in the Philippines, if, for example, we become wealthy enough that we are able to espouse a welfare state system that is effective, eventually would we succumb to such dire scenarios? Is the destruction of the welfare state not just coming from the big companies, but from the people themselves?
Yes, well, I hope so. I mean, I hope that your generation can muster enough strength and courage to develop a counter culture, no, to this kind of economic policies which tend to make the rich richer and the poor poorer. During my time when I was a student, the counterculture which we tried to develop was much stronger than yours because we rallied in the streets, we demonstrated in Malacanang, we had massive demonstrations against the American president when he visited here, and we staged rallies in front of the American embassy. But no such counterculture thrived. And so I'm not that sanguine insofar as development of a counter culture is concerned. Even in the United States, also during my time, they had tried to develop a counter culture, like the hippie movement all over the country, and even the Black Panthers and so on. But all of these were merely short outbursts of youthful idealism. So with respect to the ideology of globalization, you can see that even the communist countries, the socialist countries, the Greens, the environmentalists, and so on, also favor liberalization and deregulation and privatization. So the ideology is alive and well. And if even communist countries can accept these principles, I do not see how youthful enthusiasm and small dissident movements can back it.
Okay, any more questions? Yes, ma'am.
Dean, I feel sadder after your lecture than before I entered Malcolm Hall. The depth of your lecture, which I appreciate very much, makes me realize that we have little and fewer choices as a poor country. I wish our leaders, executive, legislative, and judiciary, would hear your lecture because somehow it points to where we are heading. Do you see any point or fulcrum for a poor country like us from which we can leap to? Is there light at the end of the tunnel?
Yes, of course. There's always light at the end of the tunnel, although that light may be the headlights of an oncoming train. So, since we are a poor country, we are in a similar situation with the poorest of our countrymen. You know, poverty is a vicious cycle. Those who are poor are also ignorant. Those who are ignorant are illiterate. Those who are illiterate also suffer from diseases and so on. So the light at the end of the tunnel may be a different kind of light.
Okay, any more questions? Yes.
Good afternoon. Hi,
Good
I'm Justine
afternoon.
Sanchez. I'm not a student of the College of Law. College of Science po ako. Yung tanong ko po, since I'm not a student of law or ever hope to be, parang, no offense po. Para
It's
bang,
okay.
ayun.
Yes, in fact, you're lucky.
Ganun. Ano po, what do you think, I mean, is there something we can do? I mean, we're not lawyers, I'm a scientist, I'm going to be a scientist, a doctor even. Ano po yung magagawa namin in light of this situation?
Will you kindly repeat the question?
Sorry. Since I'm not a person of law or will be involved in law, ano po yung magagawa ko bilang, I don't know, a scientist, a civilian, something like that, in light of the situation we're in right now?
Yes, well, I think that you, like all citizens, can pressure our leaders to adopt much more humane and progressive economic policies than what we have now. No? For instance, our leaders are all sold to the idea of scrapping all of our nationalistic laws so that we can attract foreign investments. And I'm not too sure that we should do that, or we should go to the extent of amending our constitution. We abolish nationality requirements on the ownership of land, for instance, and the rich nations will certainly come in and develop these lands. But the profits will go back to them, and only a trickle will go down to the Filipino people. So, since the rich nations, which are creditor nations, can print their own money, they can buy our lands here with printed money, and they would not care less. In our case, we cannot print our own money anymore because we are prohibited by the credit institutions from doing so. So China can come here and use its printed money to buy up all the agricultural lands. Since it needs oil, it will devote all of these lands devoted to rice and corn to Jatropha, just so they can have energy and so on. And they have done that in Africa and so on. So we have to be more discerning in doing away with nationalistic provisions of our Constitution and even with our trade and business laws.
Thank you.
Okay, any more questions? Yes, sir.
Hello. Good afternoon. I'm Tilde from the
Good afternoon.
System Information Office. Yun. Nagko-cover lang ako pero gusto kong magtanong. Sir, with Wall Street being occupied, hindi kaya siya indication na hindi train yung nasa dulo ng tunnel kahit papano? Kasi yun nga sir, sa ngayon yung the center of globalization and capitalism occupied na siya ng mga tao. Tapos yun, ewan ko kung narinig nyo na, pero sa social networking sites nang kumalat yung news na occupied na po yung Wall Street. Ayun, ano pong tingin nyo dun sa ganong pagkilos dun sa sentro ng imperialist US? Ayun po.
Hindi ko pa narinig 'yon. Ano yung
sir, yung
advocacy niya?
Yung Wall Street po, dinudumog na siya ng mga tao, tapos doon na natutulog, tapos may mga placards na, yun, we are the 99%. Tapos hindi siya nire-report pa ng mainstream, I think. Tapos yung videos tsaka pictures, kumalat lang sa social networking sites, then hindi pa siya hindi pa siya kumakalat. Syempre kailangan yun i-censor ng US kasi 'di ba pahiya sila noon yung Wall Street mismo. Kinukubkub na nung mismong citizens ng Amerika. Ayun po.
Well, magandang signo 'yon, Kaya lang itong mga ganitong pagdudumog sa Wall Street parang sandali lang at kaunting tao na naman ang involved doon. Kaya lang we should not lose sight of the fact that under globalization, wealth and currencies can easily pass from one national border to another. Yung mga malalaking korporasyon sa Wall Street, nakatago yung corporate funds nila sa mga tax havens. Wala naman sa lahat sa Amerika. Nandun sa mga maliliit na states like Liechtenstein and even Switzerland. At sa tulong ng efficient technological devices, money can be easily transferred electronically from one country to another, which are havens for big money or hot money or dirty money or black money, as the case may be. So that is why they like globalization, because of the free movement of wealth and currency between countries and into tax havens.
Okay, thank you. Anyone? Any more questions? From 1E? Okay, from the College of Sciences.
Sorry, I didn't mention this earlier. In a talk I heard some Mondays ago, a fellow, actually a graduate, talked to us regarding her research. It was something about conus snails and...
About what?
Conus snail, something to do with a possible toxin to commercial, the possible toxin that will be used medically. So, ayun, that's what we do as a scientist, right? As scientists and engineers, we research on things, we find things, we build things. We help with the knowledge pool and all that things. But she mentioned something very important. We're not given due attention by the government, really. We have a lot of good ideas, but they're not being recognized. We're not funded, we're not funded well, we're not supported into, and we're not being commercialized as well. I mean, we have good ideas for commercialization. We could probably uplift ourselves if we were given due attention, money, resources. So I'd like to ask for your opinion as to why this is so.
Opinion on what?
Sorry. Opinion on why we're not being supported. We have a lot of researches kasi po, natural resources. The Philippines is very rich in them. And we'd like, please. So we'd have a lot of research. We find out a lot of things. We can make money from these, but we're not given due attention. We're not being supported to research further into this. Parang ganun.
Sir, what she's trying to say is if we can put some resources or money into development of ideas of scientists, try to bring out more of these talents, more of these ideas, and create things that will probably enrich
our economy.
Oh, yes. I wish that the state would have enough money for that purpose, because that is what we need now, no? But you can do it on your own. And the misfortune of poor countries is that they don't have sufficient funding for in-depth research and development. And so the citizens among us will have to do our bit so that we can contribute to the important public issues and make our voices heard in the decision-making process.
Okay.
Did that answer your question?
Wait lang. Well, oh, okay. It's probably more on the economic side, my question, I mean. But in your opinion, would it be a good investment? Would we be a good investment? Or do you think we should earn money first?
What do you mean? Would investing in our scientists, for example, and the ideas that they have, would it be a good investment, or should our scientists just try to earn their own money because the government cannot give it?
Yes. In fact, the government should redirect its efforts towards assisting the scientists do their research work. No? Instead of bending over backwards so much to attract foreign investments, we can use some money to support our scientists, because that seems to be a better investment for our future than foreign investments.
Okay, thank you very much.
Okay, any more questions? Yes, the lady at the back, and then we'll have the gentleman, and then the one.
Actually po, parang I'd like to parang follow-up lang comment to the girl from the science college, the College of Science. Yeah, I agree to the comment that the scenario now is quite sad for the Philippines, but well, we always believe that there's always hope, sir. Thank you for the encouraging words. Kasi parang I'm with government, and parang I'm quite losing hope that indeed we can make changes for our people. Parang siguro it will take a lot of effort from all sectors to be able to help us go to where we want to go. Kasi yung nakikita ko nga kunyari sa budget lang for education. I remember when Secretary Abad was the Secretary of the Department of Education, he mentioned then that kunyari the Singapore spends 7 pesos per capita for their students, tayo piso lang. So makita mo talaga doon yung discrepancy ng priorities ng gobyerno in terms of investment in human resource. Ako tingin ko personally, we should really invest in human resource kasi this will be the basis for this will be the source of our talents. If we don't do that, wala tayong pagkukuhanan ng mga scientists, wala tayong pagkukuhanan ng mga doktor. Kasi kung hindi tayo talaga nag-invest, lalo na sa basic education, wala eh. Dadami lang ng dadami yung Pilipino nang walang kakayahan, they will remain ignorant, they will remain illiterate, and the vicious cycle continues. So yun, personal advocacy ko is really to invest in education, but it will take a lot of effort to convince our leaders to do just that. Kasi nga, investing in education is a very long-term process and will take a lot of years, a lot of time for the product to be seen. And, convincing people to do just that, to give priority to that kind of investment will take a lot of efforts, and it will take a lot of collective action from the people.
Yes, that's true. And that was really my point when I said that because of our policy of attracting foreign investments. We devote a bulk of our resources to developing the infrastructure, for instance, just to lay the ground for industries, or and in an attempt to compete with other countries, we divert our resources towards infrastructure and away from social services like education, health, and so on. And that explains why sometimes globalization will tend to aggravate the misery of the poorest among us, because what we could devote to social services, we divert to infrastructure and other projects calculated to attract foreign investment.
Okay. I think we have another question from the...
Good afternoon. Good afternoon.
Good afternoon.
I am Jonathan Sale, UP School of Labor and Industrial Relations. In your book, Mestizo, the story of the Philippine legal system, Dean, you mentioned about the hybridization of the Philippine legal system because of the influences of both common law and civil law. There are some legal origins scholars, no, like Simon Deacon, who have written about the correlation between law and development, and also you have Juan Botero and others who have written that common law countries tend to regulate less, while civil law countries tend to regulate more. In the early part of your lecture, sir, you mentioned that the dominance during the last 100 years of the common law system, and even in the Philippines. Do you think, sir, if the civil law components of our legal system are enhanced, and if they become more dominant, we shall have more equity and development in the Philippines?
I think it is logical if we see the characteristics of the civil law system from and that of the common law system, because as most sociologists note, the civil law system is more amenable to political reference, while the common law system leans towards the economic reference. And so if we give meaning and substance to civilian precepts like, well, we have the ancient Roman law telling us that a person should not abuse his property if it will injure others, or Justinian's dictum that we should live honestly, injure no one, and give everyone his due, then I believe that the civil law system would be in a better position to protect at least the underprivileged sectors of our society. The civil law system created maxims of equity, which can be given meaning by means of legislation. Maxims of equity like equality is equity, or he who comes to ask for equity must do equity, and so on. And you will note that the emphasis of the Roman concept of equity is more on the substance of the law, as distinguished from the English concept, which is more on procedure. So, if only our lawmakers would give new meaning to the concepts of equity under the civil law system, I think that we would have a more egalitarian social order. So the civil law system is much more responsive to political reference because, well, in the first place, our legislators are supposed to be democratically elected, no? And they represent the majority. So with our president, who issues executive orders and proclamations, and since they are democratically elected and they are accountable to the people, they should be more responsive to the problems of the list of our population.
Okay. And the gentleman in front has a question.
I'm Benji Subido of the Department of Trade and Industry. Unlike the young lady here, I used to be a student here, unfortunately. I'd just like to ask whether an antitrust law is of common law origin.
Yes, it started in. We have the antitrust law in the United States, and I believe that is a concrete form of
Yes,
antitrust.
So, considering our political and economic situation in the Philippines, would you think that an antitrust law will work here?
Will what?
Will work.
Well, we have imported provisions of the American antitrust law in our revised penal code, no? Which is in Articles 186 or 187 of the penal code, except that no one has yet been convicted of violating the antitrust law, notwithstanding so many forms of restraint of trade here, or combinations and cartels. So again, it's a matter of political will on the part of our leaders, except that, of course, if our leaders are elected through campaign contributions of the rich families here or the big corporations, we can hardly expect them to legislate against the interest of their donors.
Okay. Any more questions? Okay. If we have no more questions, then we'll end the lecture of Dean Agabin there. And before we actually end it, I'd like to invite you all and inform you about upcoming lectures in the UP Law Centennial series. This coming November, we have the launch of Dean Merlin M. Magallona's Centennial textbook entitled Dictionary of Contemporary International Law. That is on November 10, 2011. And then the UP Law Grand Alumni Homecoming which is hosted by the UP Law Class of 1986, the Silver Jubilarians, with guest of honor and speaker being Vice President Jejomar C. Binay, UP Law Class of 1967, on November 11, 2011. So that's easy to remember, 11-11-11. And then we have the 8th UP Law Centennial Lecture to be delivered by Dean Marvic Leonen on the Constitution at its margins, post-colonial issues, and the flexibilities of legal meta-narratives, I beg your pardon. This is going to be on November 15, 2011, 2 o'clock, also here at the Malcolm Theater. And then the 9th UP Law Centennial Lecture to be given by Attorney Estelito P. Mendoza on the 1987 Constitution, A Marcos Legacy. November 22, 2011, 2 p.m. here also at the Malcolm Theater. And then the groundbreaking of the UP Satellite Campus in Taguig on November 23, 2011 at 9 a.m. And the 10th UP Law Centennial Lecture to be given by Chief Justice Hilario G. Davide, Jr. on November 25th, 2011, 2 p.m. also here at the Malcolm Theater. And then the launch of the 3rd set of the UP Law Centennial textbook, Notes and Cases. Sir, do you have any last words for our listeners? If we have no last words, I think we have the UP Law Nating Hirang. Can we stand up for that?